Welcome back to our special coverage of the Cult Mom conspiracy trial of Lori Daybell. I'm Ashley Wilcott. After less than 3 hours of deliberations over 2 days, the jury reached a verdict.
Please be seated. Do we have a foreperson? Who's the foreperson?
Yeah. Yes.
Has the jury reached a verdict?
Yes, we have.
I'm going to ask you to hand that to my courtroom assistant. I'll ask the clerk to read and record the verdict.
In the Superior Court of the State of Arizona in and for the County of Maricopa, State of Arizona versus Lori Daybell, CR 2021-001704-001, verdict count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty. Signed, foreperson. Is this your true verdict? So say you one and all.
Yes.
On the court's own motion, I'll go ahead and ask the clerk to poll the jury.
Juror number 1, is this your true verdict?
Yes.
Juror number 2, is this your true verdict?
Yes.
Juror number 6, is this your true verdict?
Yes.
Juror number 7, is this your true verdict?
Yes.
Juror number 8, is this your true verdict?
Yes.
Juror number 9, is this your true verdict?
Yes.
Juror number 10, is this your true verdict?
Yes.
Juror number 11, is this your true verdict?
Yes.
Juror number 12, is this your true verdict?
Yes.
Juror number 13, is this your true verdict?
Yes.
Juror number 15, is this your true verdict?
Yes.
Juror number 16, is this your true verdict?
Yes.
Thank you.
All right, I'm going to ask the jury to retire to the jury room for just about 2 minutes. I need to discuss something with the parties before we determine whether you're done or not. So the admonition still applies. Please go to the jury room for a few minutes.
All right, to the jury.
All right, because Daybell is found guilty, the case now in Arizona moves to the aggravation phase. It is unique to this state. During this phase, the judge has to decide if applicable aggravating factors exist beyond a reasonable doubt. Now, this is separate from the sentencing hearing, which will take place at a later date. We are under a court order to delay broadcast for 30 minutes from the beginning of the aggravating factor phase, and the judge you just heard wants to speak with the attorneys, which means speaking with Lori herself. And I'm sure then we'll find out whether or not they're going to proceed with the aggravating factors today. I want to bring back in guest criminal defense attorney Robin Nunn. I don't think it's a surprise to anyone who's watched the trial. A lot of circumstantial evidence that built up. And I think that this jury just determined, hey, there is not a reasonable doubt that Lori Daybell did conspire to kill Charles Vallow.
I think that's right. I think that unfortunately for Lori Daybell, the facts, the evidence all pointed in one direction, and it was towards her. And I think that there was a very low chance that she would be successful in defending herself in this case.
Let me play devil's advocate as a defense attorney. If you were representing her throughout the course of this trial, do you think that a criminal defense attorney might have been able to cross-examine the witnesses better and differently and know strategically whether or not to actually present any evidence in her defense? It's not required. Lori didn't do it, but a defense attorney might have said strategically there was something that would be good to present. Do you think it could have or might have even been a different outcome if she had chosen to be represented by an attorney?
I definitely think so. I wasn't coaching on the sidelines or questioning, everything, but I was watching the trial, and there were objections that she missed. There were areas and lines of questioning that I would have gone down that she did not. I know that she seemed to be getting along with her advisory council that was there with her during the trial, but she was still leading the show, and she is not an attorney. And I think there were several instances where she missed. And I think that a trained lawyer, while, never a guarantee, would have had a greater chance of pointing out some of the inconsistencies and perhaps providing some level of doubt or another strategic line of thought for a jury to go down.
Yeah, and one of the things she did grasp, but I think an attorney would be better able to present, is the fact that first the jury had to find it was a murder, because we know Alex Cox, prior to him dying, said this was done in self-defense. And I do want to talk, or listen rather, to Lori saying exactly that, which is there's a right to self-defense. And that was her position, that that's what it was. Let's listen to that together.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was, self-defense, and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense.
All right, Robin, so here's what I'm thinking is she did get it. She did get that she needed this jury to believe it was self-defense, because then she couldn't be guilty of conspiring to a crime. Obviously, the jury didn't buy it, but at the end of the day, there was some evidence that Alex said this was self-defense. Why do you think a jury may not say, well, we're not going to believe that, though?
Yeah, I think that there wasn't necessarily a smoking gun in this case, such that it was, without a doubt that it was her and that this was intentional. However, there was enough circumstantial evidence, and unfortunately, her deciding to sort of, go it alone, I'm not sure that she had a very realistic understanding of the risks and the ability to navigate them in a courtroom. And I think that at the end of the day was the pitfalls. I think that there was strong evidence, strong circumstantial evidence that could lead one to conclude. And that's exactly how the jury came out. I think she would have been better served if she had gotten a trained lawyer. I know she spoke to the media and said that she's been living this case for the last few years and that she would be a stronger advocate for herself than a lawyer who had to get up to speed in a shorter amount of time. I just don't think that's the case. I think that she would have had a more objective defense if she had worked with a trained lawyer on this.
Yeah, I think you're right. I do want to listen back to some of the testimony, because Kay Woodcock was one of the witnesses, and she's the one who was the recipient of the life insurance policy belonging to Charles Vallow. Lori Daybell didn't know that perhaps at the time of the murder, and I can say murder now because she's now been convicted of conspiracy to commit murder. Let's listen together to some of Kay Woodcock's testimony in this trial.
Ms. Woodcock, where were you on July 11th, 2019?
At home in Lake Charles, Louisiana.
Were you aware at all of the relationship between Charles and Tylee?
It was, let's say, it was a bit contemptuous. It seemed like there was always a lot of drama going on, and so that's all I knew. He didn't say too much about it, and I didn't pry.
But you knew that there was some kind of contention going on with those two for a while.
I can't hear you.
I'm sorry. You did know that there was some kind of contention going on with those two for a while?
Yes.
Okay. And you weren't really aware of the events that happened that morning, were you?
The morning of his murder?
Of July 11th?
No, I wasn't.
Okay.
Because you didn't tell me.
Ms. Woodcock, did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Thank you. No further questions.
So was Charles in her life for most of her, like, memorable years?
Exactly. Yes, he was.
And how old was she in July of 2019?
She was 16. Yeah, yeah,
So teenager.
yes.
In terms of their relationship, are you saying that Charles and Tylee never had good times?
Oh, I'm not, no, I'm not saying that. I saw them have good times, and it wasn't, it wasn't that they couldn't look at each other, or, it wasn't like that. But, I mean, yeah, a teenage girl on one is hard anyway, but I do know that there was a lot of issues with her dad and Lori with her ex-husband and custody, and it was a mess. It was a mess.
So Tylee had a lot going on in her life,
Yes, she did.
and you would see her and Charles at times have difficulty getting along.
I never really saw anything that sticks out in my mind. But I just know he'd tell me how it was just difficult. And as a step parent, it can be very difficult. I can attest to that.
So on July 11th, when Charles Vallow was killed, did you actually have any idea that your brother was dead?
None at all. How would I know?
So in terms of you learning that your brother was dead, it was never from Lori
Or
Vallow.
from her.
It was,
It was from Google that my husband found.
thank you. I have no other questions.
All right, Court TV legal correspondent Kelly Craft is covering the trial. She was inside the courtroom during the verdict, and here she is. Kelly Craft, great to see you.
Hi there, Judge Ashley. Yes, we just came from being inside that courtroom where the verdict was read. We had gotten notice that there was a verdict in this case, so of course we rushed into the courtroom. At first, the security does not let people in, so you have to line up. So many people were milling around. And then we did get inside the courtroom. Still, it took some time for the jurors to get back into place and be brought into the courtroom. The judge even said it's been about 45 minutes since we announced that there was a verdict in this case. And then the jurors were brought in. And then we heard the verdict. It was interesting sitting inside that courtroom, Judge Ashley, because the clerk that ended up reading the verdict, she read many, many things before she actually then announced the verdict. It was very long-winded what she was saying. And so many of us that were sitting there were anxiously awaiting to hear guilty or not guilty. It seemed like it took a very long time for her to get to that verdict. And then that verdict was guilty. In regard to reaction, I was taking a look at Lori as that verdict was read. No real reaction from her or a reaction from the side of the state, the prosecutor's table, so no real reaction from them. When the jurors came in, I always watch the jurors as they make their way into the courtroom after we have heard that they have reached their verdict. I noticed one of the gentlemen, as he was making his way in, he turned and looked over at Kay Woodcock. And I have noticed throughout covering a lot of these trials, usually that's a pretty good indication that they are going to come back with a guilty verdict, because he did take a look at Kay Woodcock, kind of smiled, and then he made his way to the seat. And then, of course, we did hear that guilty verdict.
Ah, what great insight. I have to tell you this, Kelly, as well. When they polled the jury, which is not atypical when there's a guilty verdict, I felt like every juror was very clear, articulate, and somewhat loud when they said, yes, I agree. guilty, guilty, guilty. And I felt like there was such a level of I don't know, this is it, yes, we found guilty, and really no doubt when I heard those voices.
Yeah, and that's a good assessment of how they said that when the jury ended up being polled, and a lot of them even afterwards when they had to retire back. So what was happening is, so they looked at Kay Woodcock in the front row. I'll describe it to you, in the front row of the gallery. So we have Kay Woodcock, who is sitting there, who is the sister of Charles Vallow, the victim in this case. We also have Brandon Boudreaux, who was sitting in the front row. So his trial, the trial that Lori will be on, for him, that will be coming up in June. So that was an attempted murder on his life. He was sitting in the front row. He was married to Lori's niece, Mel. So he was there in the front row as well. And then other family members were gathered around, then a lot of general interest from the public, a lot of the media. We had the back 2 rows. So that's how the courtroom was set up. So then, if there was a guilty verdict, which there was prior to the reading of the verdict, the judge had talked with Lori as well as the state and said, if there is a not guilty verdict, we will conclude. The jury will go home. But if there's a guilty verdict, then we will go right into the aggravation phase. Lori asked if she could just stipulate to those factors. So the judge said, well, let's wait. Let's see what happens. Then, of course, they came back with the guilty verdict. The judge had the jurors go back before he released them, because then the aggravating phase was going to start. But then Lori did say again, she wants to stipulate to those factors. I want to read those factors to you that she ended up stipulating to, that she had an accomplice, that this involved an accomplice, that the victim's family or the victim suffered emotional or financial gain, as well as there was one other factor that, let's see where if I can find it. Well, there is one other factor. It was a violent offense, of course. And of course, so Lori stipulated to these. The jury would have had to find beyond a reasonable doubt that these factors existed. The judge would then take that into consideration. Lori ended up just stipulating to it. Before she did so, the judge said, please confer with your assigned counsel. She did. Then he did a colloquy with Lori to make sure she understood that what she was doing here and that it was knowingly and intelligently and voluntarily made. She said that yes, that she's not under any alcohol or drugs to impact this decision. So she stipulated to those factors. So the jury has been released.
Oh my gosh, I'm a little bit surprised, and okay, so much I want to say, because Kelly, we heard the judge when he said prior to the verdict being read that we would need to do the aggravating phase of the hearing with the jury if in fact it was a guilty verdict. And Lori said then, I want to stipulate, it doesn't matter, it's the same sentence. He then was very gracious in explaining under Arizona law we would need to have the jury find that it was aggravating factors as well as that it was a dangerous crime that was committed. And she still said, no, I just want to stipulate. What I didn't know until you just shared with us is that that was the decision that she made. Robin Nunn's still with us. Robin, let me ask you, are you surprised? You and I talked about it, and I said, I hope she gets a chance to talk to her attorneys on standby before she does that. Clearly she did that, as Kelly just explained, and she still decided to stipulate. I'm a little surprised. And as a lawyer, I think if there are any appellate issues, to stipulate to these things takes away from some of those potential issues in my mind.
Yeah, this is really tough for me to watch and listen to, and in particular as an attorney, it's not clear to me whether she understands what she's stipulating to. Before the verdict even came in, she was offering to stipulate to this. It's just really sad. It's kind of an access to justice issue for me, is whether or not her representing herself going through this whole trial, if she appreciates what she's saying and what she's sort of setting herself up to here.
And Kelly, I know we have to take a break, but may I just ask you quickly, we could see the back of her head when the verdict was read. I didn't really see that she acted any differently or reacted to that verdict.
You are correct, Judge Ashley. When she made her way into the courtroom prior to the reading of that verdict, she was smiling like usual when she walked in. Did her smile over at counsel tables, looked back at the gallery, did a smile, sat down. No real reaction than what we've seen from her this entire trial when that verdict was read.